In 1839, a group of kidnapped Africans seized control of a Spanish ship and, in doing so, forced the United States to confront a legal truth it had been avoiding. The revolt took place aboard La Amistad. The men and children on board had been illegally trafficked from Africa after both Spain and the United States had already signed treaties banning the transatlantic slave trade. Their captivity was unlawful under international law, even if slavery itself remained legal inside the U.S. When the ship was intercepted, Spain demanded the Africans be returned as property. The U.S. government initially backed that position. That is the part people tend to skip. The law existed, the treaties existed. What was missing was the will to apply them. The case reached the Supreme Court, where abolitionists argued that international law was not optional. Former President John Quincy Adams made the case that treaties banning the slave trade meant these men were free and that they had the legal right to resist their unlawful imprisonment. The court ultimately agreed in United States versus the Amistad. It ruled that the Africans were not property but free people acting in self defense. This matters now because international law still works this way. It is praised as foundational, then quietly ignored when it becomes inconvenient. The Amistad case shows that global law is rarely enforced out of moral clarity. It is enforced when resistance forces a reckoning. If you are wondering why international law feels selectively applied today, this is not new. The pattern is old, the receipts are documented.